As we've been discussing, Conservative leader Pierre Poilievre is accusing the Speaker of censoring him after he called the Prime Minister wacko and was removed from the House of Commons for refusing to withdraw that remark. Was Speaker Greg Fergus justified, and what does this extraordinary moment say about the state of Canadian politics? Later this hour, the Power Panel is here for that discussion. Sticking with Conservative leader Pierre Poilievre, he was facing more questions today about his plans for criminal reform should he become Prime Minister. Speaking yesterday to a room of police officers, Poilievre suggested he would use the notwithstanding clause to change those laws, something a federal government has never done before. It gives parliaments the power to override the Charter of Rights and Freedoms and the Supreme Court.
All of my proposals are constitutional, and we will make them constitutional using whatever tools the Constitution allows me to use to make them constitutional. I think you know exactly what I mean. They will happen and they will stay in place, and I will be the democratically elected Prime Minister, democratically accountable to the people, and they can then make the judgments themselves on whether they think my laws are constitutional.
Well, today the Conservative leader was asked to clarify. Have a listen to this.
I think that Justin Trudeau believes that it's all right for there to be concurrent sentences for a mass murderer who killed six innocent Muslims murdered, and he gets only 25 years. I think that's a disgrace. And when I'm Prime Minister, he will stay behind bars, and he will only come out in a box. It will be consecutive sentences, so it'll be 6 life sentences, and we're going to make sure that it is jail, not bail. It's going to be hard time for hard crime.
It's the courts that decided that, sir. So what does that say about your view of the courts?
It says that my view is that I will decide in my platform. Thank you.
I'm joined now by constitutional lawyer Sujit Choudhry and former president of the Criminal Lawyers Association, Daniel Brown. Gentlemen, thank you so much for joining me today. Appreciate it.
Thanks for having us.
Daniel, I wonder if I could start with you. What's your reaction to what the Conservative leader said there in his comments to reporters today and in his speech last night?
I think it's alarming, really, to hear somebody who may be the next Prime Minister of Canada promising to essentially campaign on the idea that they're going to take away people's constitutional rights, people's protections against torture, protections against unreasonable state abuses in order to accomplish something that is really already accomplished by the fact that Mr. Bissonnette, the person accused of or found guilty of murder, is already serving a life sentence, not a 25-year sentence, a life sentence already. So really, there's a lot of politics at play here, but this isn't a situation where we need to gut our Constitution in order to achieve keeping one person in jail.
So, Sujit, Pierre Poilievre says he would use whatever tools the Constitution allows, which includes the notwithstanding clause, because it is in there in Section 33 to pass the criminal laws that he wants to put in place. And he said there in that last answer, I will decide. In my platform, I will decide where this goes. Help me understand what that could possibly mean.
Right. So the notwithstanding clause in the Constitution permits a parliament or a provincial legislature to enact a law that is shielded from charter scrutiny in relation to certain rights, including the rights that Daniel's talked about regarding the criminal legal process for a period of 5 years. And so it's a clause that's not been used that frequently in Canada. It's never been used by the federal parliament. And until recently, it wasn't used very much by the provinces after the 1980s. But since 2018, we've seen the rise of the use of the clause by provinces, and now we've seen that potentially moving to the federal level as well.
Well, what would the implications be, Sujit, of the federal government using it? We've seen this in Quebec, Saskatchewan, Ontario, and other provinces, as you pointed out. But what would it mean for the federal government to use the notwithstanding clause to, in this case, it sounds like Mr. Poilievre is saying, to overrule essentially a decision made by the Supreme Court?
Yeah, so it'd be quite dramatic, because essentially what that means is that the law is placed beyond judicial review, and so someone whose rights have been violated by a law can't challenge it. And I think what is worth reflecting on a bit is that the clause is quite easy to use. And so you don't a parliament or a legislature doesn't need to wait for a court to strike down a law before they use the clause. It can be used preemptively. And as well, all it takes is a simple majority in Parliament or in a legislature to use the law. And so, the fact that the override has not been used that much is kind of really been a product of Canadian political culture since 1982. But things seem to have taken a different turn in the last few years, and it quite frankly concerns me.
So, Daniel, on the law and order agenda, the Conservatives, when Stephen Harper was Prime Minister, they've had some challenges with the Supreme Court on their, mandatory minimums and some other sentencing and bail restrictions they've tried to bring in. A lot of those were overturned by the courts. You've heard Mr. Poilievre talk about jail, not bail, and seems determined to do this. He wouldn't say explicitly how many times or how frequently he would use the notwithstanding clause, but can he achieve the sort of bail reforms his rhetoric suggests he's seeking with the current jurisprudence that exists in the country without using something like Section 33?
Well, absolutely. I mean, our courts already protect the public. One of the factors in bail is whether the public safety is at risk. And it really is a bit of a false narrative to suggest that we are unsafe because some people get bail. I mean, people get bail all the time because there's a presumption of innocence in Canada and a constitutional right to bail. What we know is that someone who uses this notwithstanding power, its first use won't be its last. And while we may tolerate the fact that someone else's rights are being removed or violated, what happens when it's our own rights that are being impacted, when the police are able to barge into our homes without any reason or conduct sort of surveillance without any type of oversight, to detain us, to indefinitely lock us up, to take away abortion rights, to enact slavery. I mean, these are all things that are protected in our present Constitution, all things that the notwithstanding clause would allow any government to override. I mean, it hasn't been used in 40 years, and to think that it would be used in this particular case to impose what a court has already deemed to be cruel and unusual punishment towards prisoners is really just, surprising, shocking, and that this would be something that people are campaigning on is something that really should cause a lot of us to question whether or not these are the right types of leaders for our country.
Well, Daniel Brown, just to stick with you, I wonder what your thoughts are on this being argued this way at the national political level. When, was it last week, we saw the Umar Zamir verdict where he was acquitted of the charges of killing a police officer. And if you go back to when he was awarded bail without people knowing what the information was because of the publication bans around the evidence and the information, the mayor of Brampton, the premier all weighed in on this, saying it was irresponsible to do this. And what are your thoughts as someone who represents people in court on seeing court processes so politicized?
Yeah, I mean, the Zamir case is the perfect example of why we can't just deny everyone bail and why we need to respect the presumption of innocence. Because what we know in this country is that not everyone accused of a crime is guilty of a crime. There was due process for Mr. Zamir. Mr. Zamir did get bail. He did follow all the rules. The public was never at risk. He had a fair trial. And at the end of that trial, he was acquitted. And so he was able to, while he was placed in custody for a period of time, while it was sort of waiting to establish whether or not he had a good plan of release. Once he was able to present that to the court, he was entitled to be released and entitled to the presumption of innocence throughout the trial. So to allow for Mr. Poilievre or for others to say that we need to eliminate bail, deny bail more often, make it unconstitutionally difficult to get bail is something that anyone should find chilling, because anyone could have been Mr. Zamir, anyone could have been in that situation, and the thought of anyone spending 3 years in jail unnecessarily should be a frightening thought.
So, Sujit, regular viewers of this show will recognize you from your appearances in many of the public inquiries into the conduct of the current government, including the use of the Emergencies Act, which you've been a critic of, and we've seen they've been found by the federal court to have engaged in overreach there. When you look at something like this, is there a justification at the federal level for using the notwithstanding clause in your view? I mean, especially when it comes to dealing with a decision by the Supreme Court.
No, I don't, and I agree with Daniel that I think the Zamir case is a healthy reminder of the importance of due process and how any one of us through misfortune could end up as an accused in a court of law and needs a full protection of the law. I do think though that we shouldn't just focus on what's happening or what might happen at the federal level. As you know, the clause has been used by Quebec, by Ontario, by Saskatchewan, and by New Brunswick. And so I think we need to have a broader national conversation about whether it's too easy to use the clause and to adopt legally binding mechanisms to make it harder to use. We can't get rid of the clause except through constitutional amendment. That would be impossible to do. But I've sort of been suggesting with my colleague George Anderson for the last several months that governments can make it harder to use by enacting legislation that requires a supermajority in a legislature, and also can only limit its use only after a Supreme Court strikes down a law that Parliament then reenacts with the override.
Well, that's the key thing there, Sujit, because if the court makes a decision, it has gone through judicial review, there's been a verdict rendered on its legality and its application towards individual rights, and then Parliament can act with the country knowing exactly the implications of the actions they're taking. What we're seeing increasingly, just to give you the final word, is provincial legislatures doing this preemptively and proactively, so it can't even be challenged and reviewed in some cases.
Yeah, and I mean the Exhibit A and B are, of course, Bill 96 and Bill 21 in Quebec, but of course it's been used preemptively in Ontario. It's been used in Saskatchewan last fall. It was used in New Brunswick, and it's quite frankly not how the framers of the charter thought it would be used. Alan Blakeney, a New Democrat, Peter Lougheed, a Tory, Bill Davis, a Tory, all felt that the override should be used as a last resort, only after there was conflict between Parliament or a legislature and the court, and after the court had weighed in with a considered ruling. They never imagined it would be used preemptively, and we should try to find ways to prevent it from being used that way, because it shuts down judicial review and it denies the public the ability to use a court judgment to decide whether the override should be used or not.
Okay, Daniel Brown, quick 20 seconds. What do you make of Sujit's idea there of a supermajority in Parliament to require the use
I think what we really have to do is rethink what tools are available to the government to just simply disregard important constitutional rights. Sujit makes some amazing suggestions. There's others that need to be considered. But right now, what's clear is that even though no government has used it, any government can use it at any time, even take away our right to protest governments doing this very thing and our ability to protest governments at all. So we have to think about what the implications are to allow government to come in and take away these rights and what it means for us in the future.
Daniel Brown, Sujit Choudhry, I appreciate you both taking the time to speak with me today. Thanks for joining us.
Thanks, it's been a pleasure.